Hey guys, welcome back to the channel. Today we got two sovereign citizens who couldn't win in court even if the entire supply of breakfast crayons was on the line. We're kicking things off in Michigan with a real standout. A guy who thought it was a brilliant idea to take out credit cards in his own name, openly admit on the record that he used them, and then tell the judge there was absolutely no way the creditors could ever get their money back. Yes, he really is that smart. But before we get into it, a quick word from today's sponsor, Exter. Big thanks to Exter for sponsoring today's video. Now, let's get into it.
All right, we are on the record. First matter is Amex versus Jason Campbell Everett, case number 243818GC. Is counsel here for the plaintiff?
Yes, Your Honor. Dreek Gertzberg, P80136, appearing on behalf of Plaintiff American Express.
Good morning. And sir, you are Jason Everett?
Yes, sir. I'm here on special appearance. I am
What?
the registered agent for the registered.
I'm sorry, you're not Jason Everett?
Yes, I am Jason Everett on special appearance.
All right. So, Ms. Gertzberg, this is a claim of failure to pay a credit card debt.
That is correct, Your Honor.
And I've read the answer that you filed, Mr. Everett, and you deny that there's a contract and claim that there's a statute of frauds problem on the plaintiff's complaint. Is that right?
That's correct.
Okay. All right. So we're going to allow discovery, which is a process in a civil lawsuit where each side can request documentation from the other side with regard to their claim. I'm going to allow written discovery only. And discovery will be open for 90 days. So that will take us to February 6th of 2025.
Your Honor,
Yes.
as attached to the defendant's answer were a number of what appeared to be discovery requests, a number of written requests for, I guess I would say, similar to interrogatories and requests for productions of documents, but
Okay, well then I
they
guess I
were
would suggest that your client should answer them.
well, they were not presented in the appropriate manner. They are not in conformity with the
Well, counsel, you
the
can
court
either have
rules.
your client answer them or you can file an objection.
At times, I can't help but question whether interrogatories prepared with that level of care could possibly constitute a valid objection.
And then the court will take them up. The purpose of discovery is to allow each side to discover what the other side's claim is. And so if your objections are just going to be based on form only, I'm probably not going to be terribly concerned about the form, particularly where the defendant is unrepresented in the case. If there are some substantive issues, then you'll need to brief the issues and bring them before the court with the proper motion. So witnesses need to be exchanged by February 6th of 2025. Exhibits need to be exchanged by February 6th, 2025. And motions may be filed and heard as permitted by the court rules. We will set this matter for a non-jury trial. That'll be a Friday. We'll need some date after March or in March or later.
March 14th,
March 14th
9:30.
at 9:30, and that'll be in person here at the courthouse.
I just can't have my client have to respond
Hang
to
on just a
50
second, counsel.
interrogatories.
Just a second, counsel.
March 14th.
I'm sorry, counsel, did you have something you wanted to say to the court?
I can't, in good faith, have my client answer 50 interrogatories.
Well, I guess, counsel, I think I've tried to direct you as to what your ability to respond to those are. So I'm not going to practice law for you, Ms. Gertzberg. You'll need to do it for yourself. So we will schedule the matter for a non-jury trial in person, March 14th at 9:30. And is there anything else for the plaintiff?
No, Your Honor, thank you.
Okay, anything else for the defense?
Judge, I'm just curious on why this counsel is here when I have another counsel on my paperwork.
Okay, Ms. Gertzberg, can you explain your involvement in this case?
We work at the same firm. The appearance of counsel of one member of a firm is the appearance of all members of the firm.
Okay, all right. So I think that that
Fair
is
enough.
pretty common response, and I think that is acceptable. So
Fair enough, yes.
okay, all right then. That's all for the record today, and we'll send a copy of this pretrial order to both parties. Thank you.
Thanks, Judge.
Thank you, Your
Welcome.
Honor.
So that concludes the first hearing. They came back a few months later, and unsurprisingly, it ended exactly how it was always going to end.
All right, next matter is American Express versus Jason Everett, case number 243818GC. It's counsel here for the plaintiff.
Yes, good morning, Your Honor. Andrew Tetro for plaintiff.
Good morning. And sir, you are Jason Everett?
Yes, sir, I'm here on special appearance and I reserve all my rights under UCC 1308.
Okay, good morning.
Good morning.
All right, this is plaintiff's motion for summary disposition. Mr. Tetro, you may proceed.
Thank you, Your Honor. Yeah, this is plaintiff's motion for summary disposition. It's being brought pursuant to MCR 2.116 C9 and C10. C9 is failure to state a valid defense, and C10 is no genuine issue as to any material fact. Excuse me. The evidence that's offered in support of plaintiff's motion establishes that Mr. Everett opened a credit account with plaintiff in November 2016. He used his card to make numerous purchases over the next few years. He accrued a balance which went unpaid. The account went into default, and now the plaintiff brings this count of breach of contract to recover the unpaid balance on the account.
Okay. There was a response filed to the motion by Mr. Everett. Did you receive the response?
I don't believe so.
Mr. Everett, did you file the response with the plaintiff's counsel?
Yes, sir, I have tracking number. I can track it.
I'm sorry, you have what?
I have a tracking number for the mailing. I can track it.
This was filed back on March 24th, is that right?
Yes, it was sent out the same day, USPS.
What's the title of the document?
Notice of judgment to dismiss for lack of contract and jurisdiction.
It's notice of motion to dismiss for lack of contract and jurisdiction.
Okay, does it also say high priority judicial declaration?
Yes, it does.
Okay, we did receive that.
Okay, would you like to respond to it?
Yeah, so the filing that Mr. Everett has filed, now it's my understanding that this is a response to the motion for summary disposition. It doesn't really address too much of what's in the actual motion for summary disposition. It does talk a lot about the UCC and Fair Debt Collections Practices Act. Most of what the plaintiff talks about, or excuse me, most of what the defendant talks about in his response is not applicable to this case. UCC doesn't apply to consumer debt, The Fair Debt Collections Practice Act doesn't apply to the originators of the debt. Yeah, most of it's not addressed to the motion. So, and also it doesn't offer any affirmative or documentary evidence to contradict that which is offered in support of plaintiff's motion. So I think at least as it stands for the C10 aspect of the motion, no counter evidence has been offered. He hasn't created a genuine issue of material fact.
You have to be kidding. All of the filings amount to exactly what they appear to be: nonsense. The defendant does have a response, and some of you may have noticed I didn't describe it as a valid one. That was intentional.
So one of the things argued by Mr. Everett is that there is no contract, and what is your position with regard to the existence of a contract? You said this is a breach of contract complaint.
Yep, there's a contract. There was a contract attached to the complaint that was filed. There's a contract attached to this motion.
Those were signed by both parties?
I don't believe they were signed by any party, but there's no requirement for a signed writing. Statute of fraud doesn't apply to credit accounts. The terms of the agreement that are attached to both the complaint and the motion are clear, and the terms of which are clear and unambiguous, that use of the account is acceptance of all the terms of the agreement.
Okay. I'm just looking at for the complaint in this manner. It's strictly a breach of contract complaint. Is that right?
Yes.
Okay. It's not an open account claim.
No, I don't believe so. I think it was just one count for breach of contract.
Okay, Mr. Everett, response?
I wholly disagree based on all of my research and based on all of the listings from UCC, listings from the Internal Revenue Code, subsection 166 on charge-off reporting. My Exhibit A was proof that the account was charged off. That basically prevents financial institutions from profiting from a debt that was already satisfied through other means, which means if it was charged off, they got a tax credit for it. I also listed in here that if they cannot enforce if they've already received benefit. That's just one of many here, sir, that are legitimate and are applicable to consumer accounts and consumer law. Statute of frauds, UCC 2201 requires that a contract for the sale of goods for the price of more than $500 be in writing and signed by the party whom enforcement is sought. They have no signatures. They have no electronic signatures. They have no wet signatures. There's quite a bit of things here, sir, that are not aligning with what the plaintiff is claiming.
Well, let me ask you this. I mean, you did have a credit card that was from American Express. Is that right?
Yes, sir.
And looks like you used that credit card for charges at numerous local locations, including Granger Waste Services, Meyer, Capital City Grower Supply, Chipotle, and they haven't been paid for those charges. Is that right?
Well, sir, my use of the without prejudice notarized UCC 1308 in connection with my signature indicates that I reserve my common law right not to be compelled to perform under any contract that I did not enter into knowingly, voluntarily, and intentionally. And I do not accept the liability associated with the compelled benefit of any unrevealed contract or commercial agreement, whether it be adhesion or hidden.
Okay. So you used a credit card and charged it up and didn't pay it off. I mean, that's really what the facts are here in the case. They don't
have any mechanism for enforcement, sir.
It's a curious approach. Admitting receipt and use of the credit card for items ranging from food to grow house materials, then asserting no obligation to repay due to an alleged lack of a collection mechanism. despite participating in that same process.
Okay. All right. Anything further, Mr. Tetro?
Nothing further other than just to reiterate the fact that he would have been provided with a copy of the agreement when the account was opened. It makes clear that use of the account binds him to the terms of the agreement. He's just admitted that he used the account. So I think the facts are kind of undisputed at this point.
Okay. Well, I do not find that there is a genuine issue of material fact. I find that the defendant did use his American Express card, did run up charges and receive a material benefit by using it, and that obviously he made some payments on the account, which acknowledged that there was an agreement that if he used it, he would pay, and then he stopped paying at a certain point in time and went into default. The court does find that his use of the credit card and acceptance of the benefit of using that credit card to make purchases does constitute a binding agreement, and therefore I do find that plaintiff is entitled to summary disposition of this claim. The various laws that were cited by Mr. Everett are not applicable, and so that's the ruling of the court. I will sign an order. Was there an order, a judgment submitted, Mr. Tetro, with the?
Yes, Your Honor. If you have the motion packet, it should be the very last 2 pages of that whole motion packet. The last 2 pages of the exhibit should be a proposed order, or excuse me, proposed judgment.
It's about a 300-page motion packet, so it's a little bit difficult to.
Should be the very last page.
Okay. Okay. All right. That's all for the record in this matter. I'll sign the order and send it to the parties.
Thank you, Judge.
Welcome.
That concludes his first case, and as expected, it resulted in a loss. He then had another case immediately afterward involving the same conduct. Let's move on to the second here.
Next matter is Bank of America versus Jason Everett, case number 243844GC. Is counsel here for the plaintiff?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722. How are you?
I'm well, thank you. Good morning, and good morning again, Mr. Everett.
Yes, sir.
Okay, this is plaintiff's motion for summary disposition. Mr. Kirschenheiter, would you like to, did you receive the response filed by Mr. Everett in this matter?
I did, Your Honor. It's titled motion to dismiss, same as the previous case, but we did receive it, yes.
Okay. All right. What would you like to tell the court?
Judge, it's pretty straightforward. It's a credit card claim. It's an account stated claim. It's a C9, C10 motion. We don't believe there's a genuine issue of fact. There's been no valid defenses pled. Defendant opened up this credit card. He used the credit card. Statements were sent to the address that he lists as his address. He made payments on the account. There's a balance due and owing. We've provided those statements showing the use of the account, as well as an affidavit as the amount due and owing. Pursuant to C9, only the pleadings may be looked at, and defendants did not technically file an answer. He filed an affidavit under the UCC, does not deny any of the allegations in the complaint. There's no affirmative defenses that have been pled. Under C10, we don't believe there's a genuine issue of material fact. We believe we've got the burden with our pleadings. So we would ask that our motion be granted and judgment enter.
Okay, thank you. Mr. Everett, your response?
Yes, sir. Again, no material contract, no informant consent, no signature, no social security number listed. I reserve my rights to be compelled to exercise any compelled benefits that were hidden from me at its initiation. Same as before, sir. I don't believe they have standing for claim.
Okay. All right. Well, the court has reviewed both the motion and the response, and It's very clear based on the exhibits attached to the plaintiff's motion that that Mr. Everett did have a Bank of America card and did utilize it for multiple purchases, many of the same locations that were indicated in the previous case, including Meyer here in the Mason area. See the consumer's energy bill was paid or was charged to it. And so clearly Mr. Everett received multiple benefits by using the card. He did make some payments under the cardholder agreement, and at a certain point in time defaulted and stopped making payments. I do find that there is no genuine issue of material fact. I do find that the plaintiff is entitled to a judgment as a matter of law, and I will enter a judgment granting summary disposition for the plaintiff. Mr. Kirschenheiter, was there a judgment submitted with the?
No, Judge. I will provide an order to the court.
Okay, you may submit that under the 7-day rule.
Will do.
Okay, all right, that's all for the record, gentlemen. Thank you.
Thanks, Judge. Have a great day.
You as well. Thank you.
Well, thank you for that. Unfortunately, it didn't add anything meaningful to the discussion.
Deputy, if you would also inform Ms. Bender there's a no contact order with her co-defendant, Mr. Burns.
I will do that, sir.
Thank you. All right, are you Christopher Burns?
I'm the living man, Christopher Burns, not the entity you got on this paper charged with all cap letters.
Are you Christopher Burns?
I'm the living man, Christopher Burns, not the entity you got charged on this paper with all capital letters.
All right, I can't understand what he's saying, Deputy Malone. Can you repeat it?
I am the living man, Christopher Burns, not the entity you got charged with all cap letters on this paper.
Okay. Well, obviously you're living or you wouldn't be there. Just answer the question if you are, and you are Mr. Burns. So, Mr. Burns, you were indicted by the grand jury yesterday on a number of charges. First 4 counts, I'm sorry, just on 2 counts, I'm sorry. The fifth and 6th counts. And count 5 alleges that on or about June the 29th, 2024 in this county, you knowingly sold or offered to sell methamphetamine, a Schedule II controlled substance, in amount over bulk less than 5 times bulk. And then count 6 alleges that on about the same date, you possessed that amount. Now, each of those are third-degree felonies, which, if convicted, carry a possible prison term between 9 and 36 months, and a fine of $10,000, and a possible license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you. If you don't have the money to hire one, the court will appoint one for you. I see you filled out a financial statement. Is everything on this financial statement correct?
Yeah.
All right. When's the last time you were employed, Mr. Burns?
I don't know. I like to see the official criminal complaint against me, and I like to plead the fifth. I ain't got nothing else to say.
That concludes his first hearing. What we can take from this is that the defendant continues to rely on arguments completely detached from reality. He was able to bond out, but that's unlikely to last given his refusal to participate in the trial, which will almost certainly result in the judge ordering him back into custody.
All right. Court will find that you are entitled to appointed counsel. I'll appoint Attorney Dennis Kirk to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf.
I don't want to enter no plea. I'd like to see the official criminal complaint against me first.
Well, you're going to need to talk to an attorney first. I'm not in a position to do anything today until I hear from everybody involved in the case on both sides. So, in the absence of counsel, the court enters a not guilty plea on your behalf. I'll set a bond.
I don't want it.
Don't interrupt me, Mr. Burns. I'm going to set a bail review hearing by Zoom tomorrow at 8:30. There'll be a final, a first pretrial on your case on October the 17th at 1:00 p.m. There'll be a final pretrial on November the 20th at 1:00 p.m. And then the trial will be set for December the 19th at 8 a.m. Bond will be set in your case for at $5,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, you'll be required to pay service fee deposit of $171 prior to release to cover the statutorily required fees. If you make bond, you'll be under pretrial supervision of probation department, 117 East Main Street. Be required to report to them as soon as you're released. Then once a week for 4 weeks after that, as they determine, undergo random drug testing in my order, provide phone numbers for home, cell, and employer. Recommended by probation, will be evaluated for substance abuse or mental health issues. If there's any treatment indicated, you enroll in and file that during the pendency of this action. You'll be under house arrest at your residence at 236 East Beach Street in Hillsborough, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any case. You can attend any kind of educational programming, classes, etc., church services, and holiday family events. And also, you're not to have any contact with your co-defendant, Joey Pender. All right, we'll notify your attorney of his appointment. We'll have your hearing. If you don't make bond, we'll have your hearing in the morning. If you make bond, there won't be a hearing. Do you have any questions, Mr. Burns?
No.
All right, thank you.
It's a choice that cuts both ways. Refusing to participate in a competency evaluation will likely result in him losing his freedom, while speaking only undermines his position further. Regardless, the judge proceeds.
Okay, this is case number 24 CR 141, State of Ohio versus Christopher A. Burns. President representing the state is Assistant Prosecuting Attorney Adam King. President representing the defendants, Attorney Dennis Kirk. Are you Christopher A. Burns?
Living man, Christopher A. Burns.
I'm sorry?
The living man, Christopher A. Burns.
I can't understand you.
I'm the living man, Christopher A. Burns, not the corporation got signed on this paper in all capital letters.
Okay, so you're Christopher A. Burns. All right.
Living man.
Well, obviously you would be dead. If you were dead, you would be here. So that seems to be unnecessary. All right. Now, Mr. Burns is indicted in a two-count indictment for aggravated trafficking, possession of methamphetamine, third-degree felonies. The question of Mr. Burns's competency was raised, and so on October the 23rd, the court ordered that defendant be examined by an examiner from the Forensic Evaluation Center. I received a letter dated November 7 from Dr. Aaron Nichting, Nichting, indicating that there was an attempt made to evaluate Mr. Burns on November the 7th. On that date, he refused to participate in the evaluation, including after attempts were made to gain his cooperation. So they indicated they could not complete the court-ordered evaluation. Kirk, have you wish to offer anything regarding the matter?
My understanding is my client's advising that he fears that his right to remain silent would be violated by participating in the evaluation. I've advised him that anything he says in this evaluation would not be used in a jury trial or court trial. And he's advised me he still does not wish to take part in this interview.
All right, well, I guess there's two options here then, Mr. Burns. One is, and Mr. Kirk can discuss this, is that, you know, if there is no evidence that the defendant lacks competency, you know, the court could go ahead and make the findings since he's refusing to participate. Or I could order him to do it again. Mr. King, you have anything to say on the matter?
No, Your Honor, I'm obviously not as familiar with this defendant as Mr. Kirk. Right. I don't know anything about his competency at this point.
Mr. Kirk?
My conversations have been somewhat like what the court experienced a minute ago with the some unusual concepts and things raised. So I've been unable to really have a clear conversation with my client.
Mr. Burns, you have anything you want to say?
I've asked him to file some things, and he hasn't filed it. I asked for the verified criminal complaint in my arraignment. I haven't received it. I haven't received all my evidence. I asked for all the hard copy evidence against me.
I guess I should have made it clear. I'm going to interrupt you because you're talking about a lot of things that really aren't relevant at this point. The question before the court isn't about all that other stuff. There's a process for that. The question is whether you have anything to say about the fact that you refused to participate in the evaluation. I'm sorry?
I might to remain silent.
You're advised to remain silent?
I'm advising myself to remain silent.
Oh, okay.
Well, that's one surefire way to get your bond rejected and end up back in custody. Just refuse to participate in your own trial. That wraps up the hearings for this guy. He was convicted and sentenced to 24 months in prison, thanks in part to his co-defendant who flipped on him to save her own skin. Now, here's the best part from her sentencing.
Well, the purpose of this evaluation is for Mr. Kirk and the court to be satisfied that you are able to consult with counsel about this matter. And in order to do that, there has to be effective communication, and he's indicating that that's not the case, and he believes, or he's concerned, and the court's concerned, that that may have a bearing upon your ability to participate in the trial. And so, you know, you're going to need to be evaluated. So it's going to be the order of the court that you be taken into custody pursuant to section 2945.371 C2. The defendant has been released on bail and refuses to submit. So the court is amending the conditions of bond that bond will be suspended until such time as he has met with the examiner and participated, upon which time, upon receipt of the confirmation that he did that, the court will then allow him to be re-released on bond. Court will order that evaluation take place within 20 days. Right. You're remanded to custody.
So, it turns out crime does pay in years behind bars. The takeaway? If you're a sovereign citizen planning to commit felonies, make sure your accomplice is also a sovereign citizen who refuses to let the court have jurisdiction. Better yet, just don't commit felonies, or you'll end up exactly like these two clowns. At least they'll get out of prison at the same time, and can go on to become repeat offenders together. That's it for today's video. I love watching sovereign citizens lose just as much as you do. If you liked the video, hit that like button. If not, feel free to hit dislike. But don't forget to leave a comment below and subscribe with notifications turned on so you never miss any of my content.